Number 59, White versus Cuomo. Counsel?
I'd like to reserve 2 minutes for rebuttal.
2 minutes, sir.
The legislature may, consistent with the Constitution, authorize a contest as a skill-based contest so long as it's determined predominantly by skill. Here we have an affirmed finding of fact that fantasy sports contests are predominantly determined by skill.
So what's the definition of gambling that we use for the purposes of the Constitution?
Well, I think that everyone is in agreement that gambling includes games of chance and wagers on future contingent events beyond the control or influence of the participants. We also know that skill-based contests where people pay entrance fees to be eligible to participate in the contest and win the prize are considered not gambling activities. The dispute that I was about to address was over the dominating element versus material degree standard. It is conceded that these contests satisfy the dominating element standard. They're predominantly determined by skill.
The dominating element test is the one that was articulated in Ellison, which is, I think, a 1904 precedent from this court. But that was specifically not the one that was chosen by the appellate division below. They chose to go another way. Is it your contention that the Third Department applied the wrong test to determine whether this activity was gambling?
Yes, Your Honor. The state does contend that there is substantial evidence to support the legislature's finding that the contests satisfy the material degree standard. But for purposes of argument, I'm assuming that the lower courts were correct that the contests satisfy the dominating element test but fail the material degree test. In that case, you would have tension between the current penal law definition and Article 14 of the racing law. The erroneous conclusion that the courts below drew was that in light of that tension or conflict, the Article 14 is unconstitutional. That does not follow. The dominating element standard, although it was articulated in the context of determining what was a lottery in the Ellison case, was thereafter used all the way up until 1965 to determine whether all manner of activities were games of chance or games of skill. So in other words, imagine if the legislature...
Those are statutory interpretations, no? I mean, Ellison was.
Yes, Your Honor, but my point is that the legislature can say that we will authorize a particular contest regardless of whether it satisfies the material degree test because it satisfies the dominating element test. And that would be consistent with the Constitution because all the way up until 1965, that was the test that was used. So if you have what is admittedly...
That was the test that was used for statutory interpretation, no?
Well, yes, but the point is that
I'm trying to go back to the Chief's opening question, which is, what is the source of your definition for gambling in the Constitution?
Well, there is no definition. We have historically the fact that around the time of the 1894 amendment, games of chance and wagers on future contingent events were considered to be gambling. We have particular activities like poker and roulette that were considered to be gambling. And we have this test that was employed admittedly for statutory purposes, but if the legislature said tomorrow, we are now going to amend the penal law and make this the test, no one could claim that that was inconsistent with the Constitution. The Constitution is a limitation on what the legislature can do with respect to gambling. It can always get tougher on gambling and prescribe more activity than is minimally required.
Can I ask a question here, Mr. Palladino? Who's responsible for defining the terms that are in the Constitution?
Well, ultimately, the court is.
The court is. All right. I'd like to take a step back into what I would call reality. Reality is that the way I view this case is that you're arguing that I cannot place a bet on whether or not the Buffalo Bills win their next game, but I can place a bet on whether or not their lead receiver, Stephon Diggs, catches the ball 10 times or 6 times. That is the net result of the argument that you're making. And I say this respectfully of you because you've appeared in front of us a number of times and you're a great lawyer. But this argument is hard for me to accept the logic of it. Can you address that?
What Your Honor's point illustrates is that one can draw analogies or parallels between fantasy sports and proposition betting, but it is also rational to analogize what the contestants do in these contests.
Well, but aren't we stuck with a particular problem in the court? Our problem is not whether or not there should be gambling or shouldn't be gambling. Our problem for this court is constitutional governance and whether or not if there is going to be gambling, that it's done legally in the state of New York without an absurd definition of what gambling is. And that would mean that we go through the process that we've gone through 6 times before, I believe, on gambling questions, and we would amend the Constitution, and done this a number of times. And I think there's a larger issue at stake here, because I respect the people that worked on this, particularly in the legislature and yourself, and I recognize that the position of the Attorney General can change over time. Those are all legitimate things. There's nothing illegitimate about that. But the terms in the Constitution are sacrosanct to the extent that the process itself has to be preserved, and that is only done when that question is put to the ultimate arbiter. And the ultimate arbiter of this question, it seems, and it always been with constitutional terms, is by a vote of the people, not by a vote of the legislature, not by a vote of this court, but ultimately by an amendment to the Constitution, and that's done by the people. That's where that power comes from.
With respect, Your Honor, that's question begging. If this isn't gambling, if the legislature has made a rational finding that this is a skill-based competition, it doesn't require a constitutional amendment. It is a general manager simulation contest. There are analogies to proposition betting, but the activity is also analogous to what general managers do. What determines
Go ahead, I'm sorry.
What determines the outcome is not the result of any particular so-called proposition bet, whether one of your players scores the points you thought he was going to score. It's how the roster that you select, which is a product of skill, and that's undisputed, how it compares to the rosters of the other contestants.
No, I understand how it works. My friends, believe it or not, I know people that gamble. They always said to me that football's tough because it's an oblong ball and it bounces funny. And that there's no such thing as a scientific outcome to those kind of games. If there were, we would all be millionaires and everyone would be successful at it. But that is not the case. But I'll let some other people ask some questions now.
Well, what Your Honor's point illustrates is that chance plays a role in the outcome of these contests. And the question is, what is the relative role of chance and skill?
So the question is, you're arguing, is the degree of chance here isn't as great as to constitute gambling?
Well, it is great enough that it passes the dominating element test, which should be enough, and there is substantial evidence that would support the judgment that even if the material degree test applied, the role of chance is not material.
So is the role of, over here, sorry, hard with the masks on. Would you say the role of chance here is greater or less than investing in the stock market?
The role of chance is less in these contests than in picking mutual funds. That is established in one of the studies that is in the record. And if you agree with the appellate division that this material degree question is somehow a de novo question for the court and not something to defer to the legislature on, and if you agree it's a qualitative judgment, not simply a quantitative one.
If that's right, why isn't playing the stock market gambling under the constitutional definition?
That's because of history. Before the 1894 amendment, even though you could logically view commodities trading and picking stocks to be wagers on future contingent events, as a historical matter, they were exempted from the definition. The salient point, though, is if you are looking at whether this is material, which is another way of saying significant, you have to compare the role of, or the degree of chance in these contests with the degree of chance in other relevant activities. And if fantasy sports is more skill-based than commodities trading, it's entirely rational for the legislature to conclude, as it did, that the role of chance in these contests is immaterial. my opponent at least makes an effort to draw a comparison, saying that, well, with this degree of chance you'd never get on an airplane, that just shows that what is material is content specific. And in the context of these contests, I think the more relevant comparison would be things like picking stocks,
Yeah, but
commodities trading, and the like.
that comparison is funny. It's in the record. The 2016 New York Times article talks about how people are successful in this form of gambling. Specifically, gamblers who are successful they will put down a bet thousands of times to the average gambler that puts down a bet 1 or 2 times. And that those gamblers are far and away the most successful. And they're very much like stockbrokers, just like most people would agree that most major firms that trade in the market are going to do better than any of us as individuals. It's the volume of their betting that controls the outcome. Nonetheless, that does not make them like the stock market. The ball is not bouncing in a funny way to determine the outcome of whether or not stocks go up or down. And so I disagree with you. I think it's an exercise in sophistry to compare the stock market to sports gambling. I think that, and I don't say this to, I understand, please, this is not personal, but it's almost an Orwellian argument. It's like saying from 1984, war is peace, freedom is slavery. Fantasy sports is not gambling. It's really like the stock market. Those things are directly contrary. The reason people make millions and millions of dollars in this is because they lose, the people that gamble, and the losers are then contributing to the 1% of the winners. And that's classic gambling in my mind. It's always been that way. And I think that this exercise in sophistry has to really be punctured through, because we lose the larger purpose, and the larger question before us is constitutional decision-making. See, I think you can allow this. You're absolutely right about that, Mr. Palladino, but you can only allow it one way. The people of the state of New York need to vote on whether or not this should be allowed.
What the skillful...
Counsel, I'm sorry. Counsel, can I interrupt you? I'm on the screen. My apologies. I know it's a little bit off-putting. Can you just, it may be that I've misunderstood how this works. Can you tell me the difference between participating in this and betting on the All-Star game?
Okay. Betting on the All-Star game is a one-time proposition bet on how you think a particular sporting event is going to come out. The outcome of a fantasy sports contest is not...
Oh, but let me interrupt you there. On the All-Star game, however, aren't you doing what you're doing with fantasy sports, which is you're looking, at least up to the point of the game, you're looking at the performance of particular players. Players are being selected by voters in a particular way, and then you've got that roster, right? And so you're measuring the success of that roster based on that past performance and who they're going to be playing with as their team member and who they're going to be playing against as the opposing, whether it's the American League, the National League, whatever side we're talking about. So I'm still having difficulty sort of getting past how this is so different from gambling when it comes to looking at the All-Star game.
Well, the predictions that a fantasy sport contestant makes in selecting his or her roster does bear some resemblance to proposition betting, but the important point is it also is very analogous to what general managers do. This is, after all, a general manager simulation contest. And as long as it is established that it is a skill-based contest wherein the contestants influence the outcome of the contest.
Yeah, but they're not, I understand what you're saying about the simulation, but it's false, because they're not the manager who sees the athlete before and after performance, during practice, who's coaching them, who's having conversations with them, who may know things that no one else will know. So no, it's not really that. I understand the companies want people to feel that way and the participants want to feel that way, but that's why it's a fantasy. No, they're not actually managers who are privy to all of the information. So in that way, the game turns solely and only on, yes, there's some skill, don't get me wrong, but it turns on what are these externalities over which they have no ability to control. Whether it's, as Judge Fahey has pointed out, the shape of the football that bounces a unique and particular way, or, the general manager who knows player X had the stomach flu last night and they're not going to be playing too good today, right? I mean, there's just different things that, of course, it is just not going to be available for simulation purposes. So in that way, it is always, the game, let me put it this way. In my view, the game cannot exist but for the real life performance. And so to the extent you're trying to have your fantasy can never really be fulfilled, as is true for so many fantasies, because you have to work in the real world.
Several things. First of all, the premise of your point is incorrect. The contestants have available to them a wealth of information, much like the analytics available to the general managers of the world. Second, the fact that strange things happen, Tom Brady might slip on a banana peel, shows only that chance plays a role. How much of a role is a factual question as to which the legislature made factual findings that should be upheld if supported by substantial evidence. And the fact that it's not able to exactly duplicate what a general manager does doesn't detract from the rationality of the legislature's judgment that
But you agree with me in your example about Mr. Brady that the participants can do nothing about that slipping on the banana peel. That is an event. If it happens, it happens. There's nothing that the participants can do about that. So it's not truly a fantasy in the way of changing that. You agree with that, correct?
Yes, but the skillful contestants are aware that such things happen. That's a random variable. The skillful contestants account for the variability in their selections. You don't put all of your money on Tom Brady. You spread your
And again, how is
around.
that different? How is that different? Okay, let's take a different example. How is that different from someone going to the horse track and knowing about a horse and knowing about all the other horses and making a calculated determination about where they're going to put their money and how they're going to bet? Play, show, win, whatever it may be.
Well, the difference with horse betting, you do not ride the horse. Obviously, you cannot control or influence the outcome. But the legislature in 1996 found horse race handicapping contests, which are essentially the same activity structured as a contest, to be a skill-based contest that's not gambling. This court, 100 years ago in the Lawrence case, found that a contest between owners of horse races was not a game of chance. It was a skill-based contest because there's skill in how you...
But that is still very different. I mean, if you're owning, in this case, chattel, and you say to someone, look, my horse is faster than yours, I'll bet you $50 that it's faster than yours, and we engage in that particular kind of bet. That strikes me as very different from what's going on in this fantasy sports that the companies have set up, where, again, the participants are not the general managers, certainly not the owners of the clubs. They don't have that kind of control. And so, indeed, they're not invested in that way that one would say an owner who's got chattel wants to make that personal kind of challenge to someone else.
Nevertheless, the contestants are exercising skill in selecting their rosters. It's a predictive, admittedly, it's a predictive contest. If there was a weather prediction contest, you couldn't say, well, that's gambling because he can't control the weather. Meteorologists will tell you that's an empirical study. It's the same thing with the selection of these rosters, that there is overwhelming evidence, not just that skillful players are winning by submitting countless entries like Judge Fahey is suggesting. They are routinely defeating randomly generated rosters. They're routinely defeating less skilled players. That shows that this is a skill-based activity. And the fact that there
Just
are...
to follow up on your example there, so if people were wagering on whether a particular tropical storm was going to turn into a category 1, 2, 3, 4, or 5, and they were putting money on that, you'd say that's not gambling.
Well, what's going on here is the payment of an entrance fee to enter into a contest. That has been historically treated differently than a wager. Here, the entrance fee is being paid to a third party, DraftKings or FanDuel, which is not participating in the skill-based contest. It's a fixed amount. It doesn't depend on how many people enter. That distinguishes it from a bet or wager. It's simply paying for the privilege to participate in a skill-based contest. So if you paid an entrance fee to enter into a weather prediction contest, you were not gambling.
Or a poker tournament?
Well, poker is different because of history. Poker existed in 1894 and was widely considered to be a game of chance. So the legislature may not be able to revisit that activity and find it's skill-based because it existed in 1894. Fantasy sports contests are of recent origin. It was up to the legislature to look at this new activity, which some people analogize to proposition betting. Others analogized it to other skill-based competitions. This was vigorously debated, and ultimately the legislature came down on the side that this looks to us to be...
But if some people can view it as gambling in a reasonable, rational way, then how can we exclude that as an appropriate definition? You yourself are saying, look, poker, maybe they were wrong about that. Maybe poker really is a game of mostly skill and not chance. And, the legislature can't revisit that because that's just historical in nature. But I'm not so sure sort of what you're arguing is the inverse makes any sense either.
Well, what I'm arguing is that new activities come along all the time. There are reasonable arguments on both sides. We've acknowledged all along this is a debatable point. The legislature is constitutionally authorized to make the initial determination into which category this activity falls. It came down on the side of skill-based competition
Wait,
for which
why-
people
why
pay
do-
entrance
I'm sorry,
fees.
why do we think that? Why do we think if this occurs in the same provision that concerns freedom of assembly, would you say that the legislature gets to make the first determination about what constitutes assembly?
What I'm saying is with respect to the factual question of the degree of skill versus chance, that is something that the legislature held hearings on and made findings about.
That's where I disagree with you, Mr. Palladino. I don't think the legislature gets to make that call. I think the only one that can make that call is this court. And then ultimately, the people of the state of New York, depending on how this court rules. And the reason for that is when the Constitution was written, the corrupting influences of gambling were so feared that they took that power away to decide on whether or not games of chance or contests of an uncertain outcome can be used as a revenue raiser because they felt it was a corrupting influence on the democracy. Now here, there's no corruption in the sense of improper activity by anyone here. The corrupting influence, I believe, is that it corrupts our process, our political process. It takes the power away from the people of the state of New York to decide this and gives it to the legislature, which they do not have the authority to do. And why is that important? Because once we start doing that, there is no stopping that. And this represents much more than the specific issue of gambling. It's perfectly proper for the legislature to submit an amendment to the Constitution and say that there is going to be casino gambling, and then the people vote on it and allow it. And it would be perfectly proper for them to consider another amendment to do this now. But the corrupting influence of allowing the process to be subverted by calling something which it clearly is not to a reasonable person's mind, I think undermines the basic principles of constitutional government. That's what's at stake here.
Thank you, counsel. You'll have your rebuttal. Counsel?
Yes, good afternoon, Your Honors. May it please the court. Approximately 6 hours from now and 150 miles east, there's going to be a very important athletic contest which any members of the court are sports fans are going to know the Yankees are playing the Red Sox tonight to determine who gets the wild card spot. Now, how are those players going to perform in that game? How's Aaron Judge going to do? Giancarlo Stanton, Derek Cole, the pitcher. How's Nathan Eovaldi, the starter for the Red Sox, going to do? Why is this relevant? Those are all future contingent events, which, with all due respect to the court, no member of the court can control how those players are going to do. My very good friend and esteemed counsel and worthy adversary can't. I can't. Nobody in this courtroom, nobody in FanDuel or DraftKings or the Attorney General's office can predict how those players are going to perform tonight. Now, we get bogged down a little bit, I respectfully submit, with respect to this skill versus chance. I say that's a false dichotomy. Skill and chance coexist in all kinds of sport. Horse racing, for example. There's no question, I won't deny that skill exists, but what the Attorney General is asking you to do here is to believe that there is no material element of chance whatsoever in this game. The legislature, by the way, did not redefine gambling.
Let me stop you on skill and chance for a second.
Yes.
Because I'm not sure why skill and chance matters here really at all. And let me explain why I wonder that.
Well, I tend to agree.
Hold on. I don't know that I can any more tell you how Garrett Cole is going to do than how Fidelity Contrafund is going to do, right? But we consider one of those things gambling, and we don't consider the other one gambling. And I'm not sure it has anything much to do with skill or chance. There are skillful people putting together the portfolio of stocks that's in the Contrafund. They have more skill than I do. Garrett Cole's a better pitcher than I am, no question about that. But nobody knows what's going to happen in either circumstance. So I wonder whether skill and chance matters to this at all.
Well,
And Mr. Palladino, I think, several times referred to history. And
Well,
I wonder if history rather than skill and chance isn't the right answer here.
I don't really think history should make a difference. I don't think the Constitution changes over time. The Constitution is constant. And as many people have pointed out here, Article 1, Section 9 occupies a very exalted place in the Constitution because it's in the Bill of Rights. And the wording of the Constitution says no lotteries, pool selling, bookmaking, or any other kind of gambling. Now, in this case, I do think, Your Honor, with respect, we do get lost a little bit and bogged down into this skill versus chance dichotomy. How do you quantify it? Is it the dominant element, as the Attorney General say? The legislature didn't say that. Now, it is true, Judge Fahey asked the question, where do we look to for the definition? This court in Dalton v. Pataki said it's up to the court to define what a lottery means. Excuse me, I have a bit of a chest cold. But notwithstanding that, right next to that word, lottery, is pool selling, bookmaking, or any other kind of gambling.
But counsel, it seems as if we've moved so far past that, because even if there is some degree of skill involved in a lottery, I think most people could easily recognize that lotteries are games of almost pure chance. And now we've moved along this spectrum to where colorable arguments are being made that there is a significant amount of skill involved in putting together these rosters, and there's empirical evidence to show that if you put together the right roster, you're going to do really well, which would confirm that there is skill involved. So I'm
I
not sure.
concede that, Your Honor.
So are we going down, we've heard that maybe this is the wrong road. Maybe measuring relative degrees of skill versus chance isn't the way to do it, that there's a historical perspective or even a philosophical perspective. But so my first question would be, are we engaging in the right analysis right here? And if we are, where's that line? Where do we draw that line?
Well, I think even though the court is the ultimate arbiter of what the Constitution says, in Dalton v. Pataki it said that, but it also said we look for guidance to the legislature. We don't have to defer completely to them, but we'll look to guidance for what it means. To that end, the court has also said when we look to legislative enactments that are contemporaneous with the adoption of the constitutional amendment, which happened, by the way, in 1894. At that time, the very next year, the legislature enacted a statute. In those days, it was Section 351 of the Penal Law. It's a different section now. But what did that section say? It said any wager or anything that depends upon the skill, speed, power, or endurance of man or beast. That's clearly athletic events. That's what the legislature itself understood contemporaneous with the adoption of the constitutional amendment in 1894. So I respectfully submit, Your Honor, I know, Judge Fahey, you observed that maybe the Attorney General's office can change over time, but I have to say that I think the arguments by FanDuel and DraftKings reek of hypocrisy. Why do I say that? Now they tell you, oh, this is a game of skill, it's very important. But what did they say before? They said, skill, this game is easier than milking a two-legged goat. I mean, that's directly opposite saying, oh, this is a great game of skill. What else did they say? These are...
Counsel, I'm sorry to interrupt. I'm on the screen. Sorry, to your left.
I'm sorry, Your Honor.
No, my apologies. So, yes, I think you've set this out in your briefing, so I'm just going to stop you here and ask you something else. Let's say we are in agreement with you in what you're suggesting about how we should consider the fantasy sports gambling. Does that mean then that the companies are bookies?
Yes.
Is that what that boils down to?
Yes. If you look at Section 225, Subdivision 9, and you look at the definition of bookmaking, bookmaking is accepting bets as a business. That's the definition in Section 225.
So why isn't it really just accepting the entrance fee, which is in part what your adversary is arguing?
Well, by the way, an entrance fee, Your Honor, is a euphemism for a bet. What's the difference? I think along here they're trying to camouflage everything to try to say it's not gambling anymore.
Well, Counselor, isn't, if you went to an illegal bookmaker, they'd say you have to pay the vigorish, right?
Right.
All right. And I don't want you to all think I spend a lot of time with illegal bookmaking, and this entrance fee is simply another form of the vigorish.
That's what it is. It's a rake. It's a vig, whatever you want to call it.
Right.
Shakespeare said, "A rose by any other name smells as sweet." And
There is one other point, though, and I think the change in position, say, of the Attorney General's office are arguing for it. You know, in our business, in the business of the law, attorneys that do that, they have a right to do that, of course, and an obligation to represent their clients. And so I think we're cognizant of and we respect that and we're aware of it. It makes for a vigorous debate about what's meaningful. And I don't, even though I might have expressed myself strongly, I have no problem with that. I understand that and respect that.
I understand, and it's an awkward position, frankly, no matter how you cut it.
Of course.
This is what they said
Counselor.
before. Now they're saying something entirely different. But I respect that.
What is the role of the legislature here? And are we to defer to them at all regarding their findings? And do you think you've met your burden to demonstrate that something was overlooked or that they didn't consider something? Talk to me about that.
Yes, well, I think, Your Honor, it's clearly the legislature, the command to the legislature, the mandate to the legislature in the Constitution is Article 1, Section 9 prohibits commercial gambling and directs the legislature to pass laws to prevent it. It is, and I really, frankly, think what the legislature has done here is bent over backwards to find some kind of way to circumvent that. Instead of worrying about the people who Article 1, Section 9 was designed to protect, average people and people who have compulsive addictions and gambling problems, which are multitudinous in this state. The problem is that they've done exactly the opposite. Rather than following that mandate, they're trying to find a way, and I believe through sophistry, semantics, and euphemisms, to camouflage this. It's like trying to thread a needle with a camel to say that daily fantasy sports somehow is not gambling, that it doesn't doesn't depend to a material degree upon the performance of athletes. Even FanDuel and DraftKings, and forget what the Attorney General says, I won't throw back what he said in previous briefs or that office, but even FanDuel and DraftKings says DFS lineups, and this is in the record, depend upon the combined performance of real-world athletes. They also said they make money almost identical to a casino. Now they're trying to go around and convince this court that somehow daily fantasy sports is not gambling. And to Judge Wilson's question, are we getting hung up here too much on the skill versus chance dichotomy? And I respectfully submit we do, because when you look at the penal law, if there is a disjunctive or, in other words, it's either a game of chance, the outcome of which depends to a material degree upon an element of chance, not whether it's dominant, but is there a material degree of chance? And the answer to that is unequivocally yes. But besides that, there's a disjunctive or. It also says, or a contingent event over which the players have no control. Now, the answer, both Supreme Court and the Appellate Division, with the exception of Judge Pritzker, whom I respect very much, but they all said, we don't buy this argument that you somehow control the outcome of the game. And the reason for that is very simply that there are so many factors that go into the outcome of a game. An errant bounce for one, a player has an off night, an official makes a bad call, a manager makes a stupid decision.
Yes, but counsel, that sort of gets us back to the stock market, right? An investor can do all the research in the world and learn the fundamentals of a company and, decide that they're going to invest in this aerospace company because it just looks great on paper, and then they design a plane that crashes every time it takes off, and the stock absolutely tanks. There's no way you could have predicted that future contingency. But I think we're all in agreement here that investing in the stock market is not gambling, as that term is defined in New York, and we are groping for a definition of gambling that allows those two things to coexist in the same society.
You would turn the financial world and society upside down if you were to equate or conflate gambling as we know it on sports betting with investing in the stock market.
I agree.
They're two different things. And also insurance. They
But
also
that's
talk
the
about why
question.
isn't
Aren't-
insurance?
When you say they're two different things even though they have similar profiles in terms of unforeseeability, chance, skill.
They do have those, Your Honor, but we also recognize, by the way, and I think this was in the brief that was submitted by Amici recently, one is, does it serve a valid public purpose? And the answer to that is yes. The stock market does, insurance does.
Well, I'm not sure you want to go down that road. I mean, there are plenty of people who think that entertainment is a valid public purpose.
Well, Your Honor, all I can say is,
Right, we're not here to make a policy judgment about whether this is good or bad, right?
it's not a policy decision, it's about what the Constitution
Right.
says. But I think without being able to exactly differentiate a stock market and in the financial world and Wall Street from gambling, there's a big difference that everybody recognizes.
Thank you, counsel. Thank
Okay.
you.
Thank you,
Counsel,
Your Honor.
your rebuttal?
On the question of whether this contest is a wager on a future contingent event, you have to determine what the relevant activity is, and the legislature determined that the relevant activity is not any individual sporting event or performance of an individual athlete. It is the fantasy sports contest itself. And since that has been found to be a predominantly skill-based contest, the participants in it influence the outcome of the contest in which they directly participate through the exercise of their general manager-like skills. So the role of skill and chance is directly relevant, because if you recognize that there is this third thing called skill-based contests, why are they not treated as gambling? People are allowed to stake money on a contest that is determined by skill. Here, the relevant contest is the selection of the roster and how it compares to others.
If Brian Cashman bet on the Yankees, put wagers on the lineup, that would not be gambling under the Constitution.
What Brian Cashman is doing is running a team.
No, I know what he's doing.
Well,
Right?
if
He's using his skill to select the players.
Well, arguably, he is influencing the outcome through his general manager
Right. And
actions.
so if he bet on those outcomes, right, that's not gambling under the Constitution.
No, because you and I can bet on the outcome of a chess match that you and I play against each other. And in New York, that is historically not treated as gambling. So if I enter a fantasy sports contest and I influence the outcome of that contest, it's perfectly acceptable for me to pay an entrance fee to the contest operator for the opportunity to participate. This court in Lawrence, contrary to what my opponent says, drew a distinction between entrance fees and wagers. The owners of the horse races, the owners of the horses paid a fee to this association that ran the contest for the privilege of entering their horse into the race. Somebody else, a third party, wagering on that is gambling. But the direct participant in the contest, which in that instance was the horse race owner.
Counsel, again, that's the problem that I have with some of your hypotheticals. The horse owner, one must assume ostensibly, has prepared that horse for the race and that they're making assessments about that horse's ability. Whereas the participants know whatever they know, but again, these players are not chattel to them. It's not an ownership relationship. It's closer, of course, to what Judge Wilson has already described in his questioning to you. And I'm having great difficulty every time you keep analogizing or trying to distinguish between the horse owner or anybody who owns, in a dog race, the dog owner, or any one of those kinds of examples from participants who pay money to come up with their dream team that does not exist but for the fact that there are actual athletes playing in the real world and the participants have no control. They don't own those players and they don't otherwise have any control over how the events will unfold. And that's why I say I keep having difficulty with your argument.
Well, the analogy is that the contestants own their fantasy team and they are stepping into the role of a simulated general manager. There is no support anywhere for the proposition that there's some kind of disqualifying type of contest or disqualifying type of skill, because skills are transferable between activities. The skills that a general manager uses are very similar to the skills that a sports
I guess,
uses.
Counsel, at the end of the day, perhaps I have sort of the same reaction that Judge Fahey has in this, if I understood him correctly, with his first line of questioning when you were first at the podium, that I find it very hard to say what I think you're arguing. It's not gambling because the companies have developed this fantasy world to divide between what happens on the field and what the participants think may happen on the field. Just because you put a little layer in between doesn't mean it's not gambling. And I think that's really where I'm having the difficulty with this argument.
Well, I would urge the court to ask itself, what is the principled basis for distinguishing among skill-based competitions? Where is the principle that says this skill-based competition is okay, but this one isn't because it seems to employ skills analogous to what sports bettors use, even though it's also similar to the skills that a general manager uses.
But in a
There is
way-
no such principled basis that I can discern.
Right.
And
In a way, you've told us that there can't be one because, for example, of poker. That some of these things are not going to be describable in a principled way. They're going to be an artifact of history.
Well, that's correct, Your Honor, but again, we have this new activity that comes along, and I think that the legislature does play a role because the legislature has constitutional authority to implement the gambling prohibition, and you can't implement it unless you first determine into which box a particular activity falls. And there are limiting principles. I mean, I think that my opponent's argument is that if you allow this contest to be treated as non-gambling, what's stopping the legislature? Well, first you have the fact that it has to be predominantly determined by skill. That is a limiting principle. The legislature's factual findings have to be rational, and it has to be an activity that didn't exist in 1894. Those are important limiting principles. I mean, the legislature comes along and says, we've now determined that roulette is gambling. That's not not gambling. That's not a rational.
But counsel, I'm sorry to interrupt you, but just because the activity didn't exist doesn't mean that the essence of the activity isn't comparable to the activity that did exist. That's again where I'm having some difficulty with your argument. You know, just because we want to say it's new because it's on a computer doesn't, you know, you can play poker on a computer, of course, but we'd still say it's poker. So the question is whether or not this really, you know, looks like Senator Kruger says, you know, it's the duck that walks and quacks like one, so it must be one. Let me ask you a question, though, about something you just said a moment ago, and I may not have taken a correct note, so you'll correct me if I've misunderstood you. I believe you said the legislature has determined that the relevant activity is this fantasy sports activity, not the activity of the actual athletes. And if that's indeed what you said, why are we bound by that determination? What if we believe that as a legal matter, that is not the correct, that is not the relevant activity that we should look to?
I will acknowledge that sounds more like a legal question than a factual question. The degree of skill versus the degree of chance plainly is a factual question as to which the legislature made findings. There's ample evidence of the high degree of skill involved. But as to what is the relevant activity, I will acknowledge that sounds more like a question for the court to decide. But in deciding it, please consider that what the contestants are doing is not predicting the outcome of any real-world sporting event. And if particular athletes on your team do not perform as expected, that also doesn't determine the outcome of the contest. What determines the outcome of the contest is the overall performance of the roster, and that selection of that roster has been shown with studies to be overwhelmingly skill-based. That makes it a skill-based competition, and if it is a skill-based competition, it logically follows that the contestants materially influence, if not control. They don't have to control, they just have to influence the outcome of the contest in which they're participating. And just because it's a fantasy contest doesn't matter, because I can articulate no rational principle for how the court would distinguish between various types of skill-based contests and say this one is good enough, but this one isn't. And the fact that it is a debatable point is a reason why this law should be upheld. If reasonable minds can differ.
What about if let's assume for one moment, of course, that we agree with you about the great amount of skill that the participants bring to bear in fantasy sports. But what about if their skill is meaningless without the skill that's external to them? Could that perhaps be one way of thinking about it? I'm asking you genuinely as a question.
Well, if it were, then the outcome would be different. But the empirical data shows that the experienced contestants, which are the ones who enter more than 1,000 contests, routinely beat randomly generated teams. If this was a game of chance, if you had lots of data, you would just see a 50-50 split between skilled players and randomly generated teams, or skilled players and inexperienced players. But the fact that skilled players are winning like 96% of the time is proof positive that it is a skill-based activity employing the same skills that general managers employ. It just happens to be a fantasy simulation, and there's absolutely nothing wrong with that as a constitutional matter. Now,
Counsel, we'll
we-
have one final, Counsel, we'll have one final question from Judge Fahey, please.
Counselor, it's my understanding that skill-placed players or very experienced players in high-stakes poker do much better than everyone else. At the same percentage of skilled players in fantasy sports do very much better than everyone else, and according to the information that was in the record. And what that says to me is that the argument you're making is in essence equating the degree of skill to be successful in poker as a degree of skill to be successful in fantasy sports. Does that equate those two activities, poker and the sports?
Well, no, Your Honor. I mean, poker is determined to a greater degree by chance than fantasy sports, but let's assume for the moment that it's the same amount of skill.
Yeah.
If this was a new activity, one could rationally maybe say that...
Let me stop you, because we've been at this a long time. If poker was a new activity, would you say that that's not gambling?
I would say that it could rationally be determined to be a skill-based contest. However, it existed in 1894. For correctly or incorrectly,
See,
it was deemed...
here's the problem with that argument. When you play poker, if somebody deals you a royal flush, you're going to win the hand. And that's how the cards are dealt. That's the way the deck is shuffled. And if you have Tom Brady as your starting quarterback on fantasy football, the odds are, if you are able to do that and have the same particular receivers and everything else, that the component elements of what you have are just like the component elements in a game of cards. Let me finish. And that means that your selections, while you get to make them, we both know that you can only make one at a time and you do them in order, and that it's the luck of the draw, just like it's the luck of the draw in poker. And it's hard for me to see any rational distinction at all between the two, except I think your argument leads us to the inevitable conclusion that poker is pretty much the same. Certainly the numbers in terms of how successful a small group of people are in poker and a small, and by this I mean less than 2%, group of people are successful in fantasy football. The numbers bear that out.
There is no random distribution element in fantasy sports, which is present in poker. The fact that...
I got to stop you. I would disagree with that, because there is. The way you randomly select in an order for your players is a random distribution element, just like how you pick a football player in the draft is random. Of course these things are random. And it's a more difficult argument to penetrate for public purposes, but it is not true.
Despite those random variables, there's evidence of the overwhelming skill-based nature. All Your Honor's point proves...
Well, I agree with you about that. It is skill-based. You know, poker players call finding poker players that aren't very good bum hunting. They're going to find guys that are bums. They're lousy at poker. And they're going to get as many of those guys as possible, because that's how they make their money, because they're so skilled no matter what cards they draw, because they understand the psychology of the game. The same thing happens in this sport.
Your Honor, it doesn't seem like there's anything that I'm going to say it's going to
Well, in
shake
fairness to you, that's
so I'll
probably
just
true.
sit
And thank you, counsel. Thank you.